So steps in succession planning. Assess the current risks and act. So by that I mean wills. So this is where are you currently? Do you have a will? All right. Who are the personal representatives or executors or trustees you will? They have a different name. The more modern terminology now is going to be is personal representative. Who is that? When we were doing a course recently as accountants, a group of accountants, one of the accountants there said, was thinking about it and said, actually I think my personal representative might be dead. I think he died about 18 months ago. But I don't know, I'd have to go and pull out my will and actually see. Yep. Who are the beneficiaries of your will? Is it the kids? Is it the kids' trust? Have you thought about that issue? Your farm assets. Where are the farm assets being left? Sometimes people think they're leaving the farm to the kid, but the farm may be owned in a trust or a company. There may be big interloans between the parents and the trust or the company. Those loans could be part of the residual estate, so they might go to someone that you didn't actually think you were leaving it to. So loans and stuff are something that has to be looked at really closely. Current accounts, so you know what we mean about current accounts, like in a company or a trust, are essentially the money that you have over time put into the company or trust and is credited to your name in either the company or trust. They are often part of your residual estate unless you've dealt with them separately and said, I leave my loan to the company to my son who's going to get the farm. Other than that, it goes to who you might have left the residual to, your other son. Well, then it would go to him and he could call that up and say, yes, Mr. Son that got the farm, I'd like you to repay the $2 million loan that Dad had advanced to the trust. And I'd like it tomorrow because it's on demand. All right, needs to be dealt with. We don't like with businesses and farms. We don't like lawyers doing wills on their own because they don't think of these things. They're accounting type things. A lot of those wills should be done with accountants or lawyers together. Accountants and lawyers together. For your trust or your will, do you have a wishes letter? Do you actually say, in terms of your trust, a wishes letter is if you've got your trustees and you're gone, what do you want to happen? All right, and this is only these sort of things. The letters they're non-binding. They're just saying, hey, listen. You know, it might be, hey, listen. I'd like everything to be divided equally. I'd like, and it depends what age you are when you're doing it too. Like if you're my age, I've got 2 young kids. I might be saying, listen, I want the money to go to my kids' education first before as a priority if that's what they want. So you can actually leave instructions about how you would, wishes for people to follow. All right. Do you have a guide to the living? A guide to the living is is a basically a file, or a foolscap folder or something. It has in it things like your will, your power. So this is something, a folder sits, sit it somewhere in your office at home. Tell the kids, listen, if anything happens to me, go and grab that folder. Or if anything happens to both of us, because it might be alright. One of you might know where the other, husband and wife, the wife knows where it is and the husband knows where it is, but what happens if something happens to both of you at once? What happens if there is only one of you? Alright, so it's a guide for your, really is a guide for the people that are left, whether that be your trustees, your personal representatives, your kids, whatever. Do you have a power of attorney? What happens if you have a stroke tomorrow, you're not able to make any decisions? The issue with that is that your name's on a whole lot of documents. How often do you have to sign a loan document? If you actually can't sign and the court says, no, you're mentally incapable of doing that, or physically, regardless of which one you are, if you haven't got a power of attorney, the only way that's going to be fixed is by going to court. Going to court to have the court appoint someone to sign on your behalf. Is that your way you want it to be dealt with? You want the court to make the decision? Or do you want to make the decision yourself now about who can act for you under a power of attorney if something happens and you aren't able to act for yourself? Memorandum of wishes already talked about. Life insurance policies or something. I had a thought about it when I was looking at it myself and thought, actually, one of my policies, in fact, I can't remember who it's owned by. One of them I know is owned by my wife, so that she's got immediate money. But there's another one, and it goes into one of the companies. I'm not sure whether it goes into the accounting practice or the investment company. I thought, well, if I don't know, how's Robin going to know? Or anyone else. Yes, it'll eventually get sorted out, but it's a lot easier if it's actually there with a copy of the schedule that actually says where it is. What about your funeral arrangements? Do you have any? So what you want for your funeral arrangements could be in there. You could have details of any valuable possessions. Hello, come back. Any valuable possessions that you might have that you want to assign to particular kids to take. You can have a list of them with digital photos now. You can actually take photos of them and write the kids' names beside them. Passwords. Actually, I forgot to mention that yesterday. Passwords. Passwords for your. What about your computer if it's got a password? Security systems, phone systems. I probably shouldn't say banking. Passwords, but particularly if one of you only deals with the finances, what about the other person? So if one of you deals with the internet type finances, what happens if you go? Does your wife know where to find all that? Can she deal with it, or can the husband? Details of bank accounts and who can operate them, investments, all the sorts of things that you just think about. If I died tomorrow, what are they going to have to go through? And how hard is it going to be for them to find it? Powers of attorney, things around director. If you're operating in a company, who's the replacement directors? What happens there? Have you listed? Replacement directors are normally appointed by whoever's left, who owns the shares when it's left. It could be your estate. Therefore, it could be your personal representative appointing the replacement director to your company, or you may have left some instructions about that. But have you? That's it. Step 2, meet with your facilitator and discuss your needs and wants regarding succession. Facilitator can be anyone, but it's someone to drive it through other than you, because what tends to happen is you might think of it and say, yeah, that's a good idea, I need to do that. And you may even start the process by getting your will out and starting. But if you haven't got someone to drive it through, often you just get busy doing the job that you're doing. Right? There's always lots to do if you don't appoint someone, whether it be your accountant, whether it be your lawyer, whether it be a family friend, whether it be one of the kids to say, drive this through for me. But it's really more someone to actually drive it through and make sure that things actually happen. Preparing a list of assets and liabilities for both mum and dad. Again, and sometimes you think, oh, the accountant knows that. We don't necessarily know it all. We know the business stuff. We don't necessarily know what might be out in personal. We might get a document that says what interest you earn, but we don't necessarily know. We don't know about your life insurances often, except that we see the payment, but we don't know what the value is and who they are. And the assets and liabilities, who owns it? Is it covered by will? Who's it to go to? So that's, you basically list the asset and liability, 3 columns. Some of the stuff, obviously, you don't normally assign the liability, but 3 columns and say who owns it now, because sometimes it's owned by you, sometimes it's owned by your trust, sometimes it's owned by your company, depends on your own, sometimes it's owned by you jointly, sometimes it's owned by one of you, because it never got changed. So just look at that. Appointing a succession team, so that's often because when we get to those, when we start getting here, we start getting to talk. When we get down to the plan side, we start talking about needing legal agreements. We start talking about needing accounting advice. Maybe the farm advisor and the banker need to be involved. Bankers are good ones to involve anyway, because it might be that one of the kids is going to need some money. It's always good to actually have them intimately involved in the plan at the start to see whether it works from a banking perspective. Number 5 is talk to the kids about their expectations, and I've got said talk there, but what I actually mean, we actually also send a questionnaire out, often sent by the facilitator, and go back to the facilitator, so it's not actually mum and dad, so they can say stuff that they didn't want to say to mum and dad. We would normally mark it as a confidential questionnaire to actually get their views and expectations, because you might think you know what it is, but yeah, maybe you do and maybe you don't. Work out who the successors are and discuss succession with them. Now, often sometimes that's quite obvious, and sometimes it's not. All right, so for some, yeah, that's relatively easy. You say, you know, they might be the only ones and they're working on the farm. It might be quite easy to say, yeah, that's who it is, and that's how I want it to go. But sometimes it's not so obvious. Sometimes kids have worked, one kid's working on the farm, the other one's working for someone else on another farm, contract milking, share milking, whatever. So it may not be as obvious. And then we start getting towards actually working out a plan. What's the best way of actually, so all the groundwork before, then getting down to working out a plan and saying, now start debating what's a plan that's actually going to work here. And then, of course, we get a plan, we're going to say, can it work financially? Is it viable? Sometimes it's not viable when you first look at it. And you've got to say, all right, what are we going to do to get it viable? And can we do that? All right, and can we put some of the steps in plan and towards that now? And finally, we come really down to just discussing the steps with the whole family and discussing the plan. Now, look, the thing there, a deed of family arrangement may be a good idea. A deed is a legal document that may get around some of the issues around it being contested afterwards, after you've gone. The actual kids have committed to the actual arrangement altogether and said, yep, we're happy with this. This is our understanding of how it's going to happen. All right.
Just on that,
Yep.
what age do the kids have to be to sign it? That it actually is legal?
Well, they'd have to be legal. They'd have to be the legal 18.
18.
Yeah.
18.
Yeah.
Right.
And going on that court case, they might have to have some independent legal advice on it themselves, because otherwise they can say, well, we weren't advised properly on that. Mum and Dad's solicitors said, yeah, no, it's okay. So, yeah, and independent legal advice at that stage too. And finally, what we've got to do there is work at each stage the succession plan, put some dates and some targets around it. Who's going to do it? When are they going to do it by? Because it will have a whole lot of steps. And look, the succession plan, we're not talking something, we say, yeah, we're going to do this. Can you get back to me next month with the plan? Send the documents out, get it to the kids, get the plan, we'll get it done by next 1 month, 2 months, 3 months. Often it can be a 2-year process to actually get there. Particularly if things are complicated. And have someone monitor the progress of the plan. Just some questions for you following on from this to think about. This is a big one. Think about this. Think about this tonight. Go home, have a glass of wine, have a beer, whatever. Think, what's going to happen if I died tomorrow? What's going to happen? And are we prepared for that as a family? All right. What is going to happen if I died tomorrow? And it probably doesn't matter how young you are in terms of that one. All right. If you died tomorrow, what's going to happen? What happens if you have a stroke tomorrow? And what happens if you have a stroke and you're no longer able to function mentally? All right. So do you know what would happen? The died tomorrow too, by the way, when you do that, extend that and say, what would happen if we both died in a car crash tomorrow? what would happen if both of us died? So think about either one of yours, then think about both of yours. Do you know what's going to happen, and are you happy with that? How long is it since you've had a look at your will? Anyone want to hazard how long it is since I've looked at their will? Someone in yesterday's group said 20 years.
Probably when I was written.
Righto. Yeah. So make sure you get out your will and have a look at it, because it could have a whole lot of stuff that's just not relevant anymore in it. And if you actually look at it, yeah, you might just go, in fact, you might find that you wrote your will when you didn't have a trust. There's a whole lot of things you want to do in your will when you've got a trust. You might have, yes, things may have changed with your kids. You might have grandkids that you actually want to leave something in the will that you never had at the time you did it. And you actually want to leave them something in particular. So just have a look at that. Have you built up any off-farm assets? So what have you built up in terms of off-farm assets? Or, you know, it may be that you actually say, no, listen, it's okay because I know what we're doing, we're selling the farm. And we don't need to worry about that side of things. But everyone's different. If you're actually thinking, hey, I want to pass the farm to the kids, what have you got that's off farm that's going to allow you to live how you want to live? And you may not need all that, because obviously you would expect certainly the kids to take on a certain amount of debt when they come in. But it's a hang of a lot easier to sort the whole thing out, especially if you've got a number of kids. It becomes more and more difficult for the successors, because there's more people that have to be paid out and they get a smaller share. So what have you got off farm? And it may apply for some and it may not be necessary for others. That's why I said it's a little bit different. Everyone's a little bit different. Do you actually know what your children's expectations are of what they will get when you pass? Do you care? But, you know, that's, if you do care, then you know what they are. And I say do you care because I told Dad to spend it all. He'd be quite happy to die with nothing, I think. So just in summary, it's not too hard on this, and it just takes some planning. You've actually just got to think about it and get it done. And you really want to start. It's something you should start early. In fact, we're talking about like those inheritance trusts. You actually want to set those up when the kids are teenagers. That's probably the best time to actually get them done. Certainly if you can, get them set up before they have partners. Even before there's a partner in the wind, if you can. Keep it flexible and simple, and that's in terms of the planning. And the plan, every situation, as I said, is different. I've got four farmers that are going to be 4 different results. There's still planning to do if your plan is actually sell the farm. There's still planning to do for that. There's still, particularly in terms of just looking at timelines and saying, hey, what do I got to do before I want to put it on the market? You know, if I want it about this time, have I got to be prepared to step in a bit earlier if we're at a high? And not just sell it the exact year I want, because maybe it's better to sell on the high year 2 years early than it is to wait 2 years and be in the low. The other thing is, think of it as parents, it's probably an obligation to actually deal with these issues while you're alive and not leave it for your kids to fight it out when you're gone. And kids argue before the parents die, let alone afterwards. And finally, like, the plan actually needs to be fair. That's okay, because otherwise we do run into issues with the courts, and you can end up with things that you just didn't expect, outcomes that you just didn't want. So wherever possible, you've got to try and make some degree of fairness. And in terms of that, when I say plan needs to be fair, I don't mean equal in that, but just mean it still has to be some degree of fairness, and so that the kids are actually happy with that. Right, any questions on that?